Episode 7, Trusteeship Explained. Hello, my name is Alexander von der Vollen, and welcome to Trusts Unpacked, where we strip away myth and marketing and explain in plain terms how trusts actually work in real family situations. For the last 20 years, my work as a fiduciary has focused almost entirely on the architecture of trusts, the skill of trusteeship, and the challenge of long-term family governance. Not as a technical exercise, but as a human one. Alongside my advisory work, I'm a published author, and I've recently completed a trilogy that reflects both the technical and the human dimensions of both the fiduciary and private banking fields. But before we begin, a brief, albeit important note. This podcast is provided for general information and discussion only. It does not constitute legal, tax, fiduciary, or professional advice, and it should not be relied upon as such. As ever, you should always seek advice from appropriately qualified professionals in your relevant jurisdiction before making decisions or taking any action. So, let's get unpacking trusteeship. Trusteeship is often spoken about abstractly, as a function, as an appointment, as a name on a document. But in reality, trusteeship is intensely personal. It carries authority, it carries responsibility, and it carries risk. So this session is most relevant to two groups of people, those considering acting as trustees and those appointing them. Both groups need absolute clarity, because trusteeship is not something you should drift into, and it is certainly not something you should delegate without thought. So let's begin with fundamentals. A trustee is not an administrator. They're not there to follow instructions, and they're definitely not there to keep beneficiaries happy. A trustee is the legal owner of trust property, acting under fiduciary obligation. That ownership is real. Let me repeat that. That ownership is real, and the consequences of that ownership are real. Trustees sign contracts. They appear on company registers. They can be sued. They can be held personally accountable. And that's where many misunderstandings begin. Families often think of trustees as custodians holding assets on behalf of others. That language is perhaps comforting, but it's inaccurate. A trustee owns the asset. They just don't own it for themselves. That distinction is the very essence of fiduciary responsibility. Trustees make decisions, they exercise judgment, they choose between competing interests. The law gives trustees power precisely because it expects responsibility in return. And that is why trusteeship cannot be reduced to mere process or compliance alone. You can comply perfectly with procedures and still fail as a trustee if you do not exercise judgment properly. Equally, you can act in good faith and still be in breach if you simply misunderstood your role. Trusteeship is not passive, it's not neutral, and it is definitely not safe by default. So let me show you what integrity looks like when it's genuinely tested with a real example drawn from my book, Trust, the Skill of Trusteeship, in 16 Success Stories and 1 Failure. In 2011, I received a call, I think it was on a Sunday, from a law firm in East Africa. A local entrepreneur wanted to meet urgently. By Tuesday morning, I was sitting across from a man who spoke little and listened very carefully. He built things: steel, infrastructure, power. He trusted workmanship more than words, having started as a workman himself. He'd grown up poor, apprenticed in welding sheds, and built his company by refusing to cut corners in an industry where shortcuts were all too common. His reputation was simple. If he said something would hold, it did. And over decades, that reputation became a business employing many people across East Africa. When we structured his trust, his instructions were clear. Protect the operating companies, provide for his 2 sons, but do not allow wealth to dilute responsibility. Above all, preserve standards. Sadly, he died suddenly. And 3 weeks after the funeral, a courier delivered a letter to me that he had written months earlier. Inside, from beyond the grave, so to speak, was evidence that one of his sons had forged documents to move funds improperly. The matter had been corrected during the settlor's lifetime. No one else knew. No harm appeared to remain. Legally, the trust was sound. There was no obligation to act. Silence would have been entirely defensible. And this is where integrity begins. Ignoring the letter would have been easy. Acting on it was going to be uncomfortable because it meant confrontation, destabilization, and risk. But the settlor had trusted me, not merely to hold assets, but above all to hold standards. So I called both sons into a meeting and placed the letter on the table. The son in question admitted it. He said it was panic, pressure, pride. The other son demanded his brother's exclusion from the trust and appropriate punishment. Both reactions were understandable. But the integrity of a trustee requires restraint as well as firmness. We did not remove the offending son, nor did we pretend nothing had happened. Instead, we tightened governance, introduced independent oversight, removed unilateral authority, and documented everything. The breach was acknowledged. The response was proportionate. The line was drawn. This trust still holds today. The businesses grow. No further breaches have occurred. The family knows that behavior matters, not just entitlement. Now, that outcome did not come from drafting. It came from judgment. So you see, integrity and trusteeship is not about moral theatre. It's about acting when discretion offers cover, but responsibility demands exposure. Trusteeship gives you power. Integrity determines whether you actually deserve it. So that's why integrity is not an attribute that trustees should aspire to. It's the minimum standard for accepting the role at all. It's also important to understand how trusteeship usually goes wrong. Not through scandal, not through dishonesty, but through erosion. Trustees accept the role with good intentions. They attend early meetings, they engage with advisors, decisions feel manageable. Then time passes. Life intervenes. Meetings become shorter, papers are skimmed, decisions are deferred or rubber-stamped. Nothing obviously bad happens, which is precisely the problem. Trusteeship, you see, does not punish inattention immediately. It simply allows it to accumulate. And by the time difficulty appears, the trustee is often poorly placed to respond. Records are thin, rationales are unclear, habits are formed that are hard to reverse. This is why trusteeship must be treated as an active role, not a static appointment. The absence of problems is not evidence of good trusteeship. It may simply mean the structure has not yet been tested. My very first trusteeship illustrates this. In 2005, shortly after having left banking, I was asked to act as trustee to a very small trust. There was no family office, no lawyers hovering in the background, no sophisticated planning. The trust had been created after the death of a British soldier killed on patrol in Iraq. His comrades in arms had raised money discreetly, soldier to soldier, to support his widow and 4 children he left behind. There was no tax motive and no publicity, just a shared sense that something needed to be done. I accepted the role without hesitation. There was no fee, only expenses. On paper, it looked simple enough. And why did I accept it? Because it would be great experience, and I was building up my trustee knowledge. In reality, it was the most demanding trusteeship I've ever held. You see, there was no letter of wishes, no articulation of intent. All I had were conversations with the soldiers who had known him, notes taken slowly over time, a picture built from memories alone, a sense of the man he had been, his values, his restraint, his pride. And that became the only compass I had. The first real test came quickly. A phone call from his widow. Hesitant, apologetic, It was, the family car had broken down. Repairs were urgent and expensive. But without the car, school runs were impossible and work became precarious. The trustee allowed me to help. That wasn't the issue. The issue was judgment. Was this within the purpose of the trust? Was it support? Or was it going to create dependency? Was it right to act quickly, or better to pause and ask more questions? There was no checklist that could answer that, no advisor who could carry the responsibility for me. Of course, I approved that payment that very afternoon. It sounds insignificant, but it wasn't. That decision carried weight. You see, once you make one decision as trustee, you begin to set a pattern. You teach beneficiaries what the trust is and what it's capable of. You teach yourself what your role really involves. Thankfully, over the years that followed, the requests never became extravagant. School uniforms, dodgy boiler, a laptop for a child falling behind at school. Each decision required the same discipline, not sympathy alone, not distance either, but careful consideration, consistency, and restraint. I learned very quickly that trusteeship is not about executing instructions. It's about holding intent when no one is there to explain what that intent is. It's about preserving dignity, not just paying bills. It's about understanding that saying yes too easily can be as damaging as saying no. I also learned something else. Trusteeship becomes personal whether you want it to or not. Every decision carries emotional weight. You remember voices, you remember pauses. You remember, as I do, what it felt like to sign that first check, knowing that it mattered. Now, years later, as the children grew into adults and the trust role gradually changed, I realized that nothing dramatic had ever gone wrong. There'd been no disputes, no crises, no complaints. But that was not because the trust ran itself. It was because every small decision had been treated equally as consequential. So that experience taught me what trusteeship really is. It's not administration, not compliance, not form filling. It's the acceptance of authority with responsibility attached, repeatedly, over time. That's the reality that trustees step into, whether they expect it or not. Let's look now at trustee powers and what trustees can do. Trustee powers come from two sources. Firstly, the trust deed. Secondly, the general law. Together, they define what trustees are permitted to do. Typical powers include managing and investing trust assets, buying and selling property, making distributions to beneficiaries, employing advisors, and delegating certain functions, and exercising discretion within defined limits. In modern trustees, these powers are often very wide. It's deliberate. Families want flexibility. Advisors want room to maneuver. Trustees want tools to respond to change. But watch out. Wide powers are also a double-edged sword. Power is not an unfettered freedom to act. Every power must be exercised for a proper purpose, within the scope of the trust, in good faith, and with due consideration. For example, a trustee may have the power to distribute all the trust assets to a single beneficiary of various. That doesn't mean they should, and it definitely doesn't mean they can do so casually. The existence of a power doesn't dictate its use. Judgment does. There's also a further distinction that I want to make. Trustee authority is legal. Trustee legitimacy is behavioral. A trustee may have unquestioned authority under the deed, yet lack legitimacy in the eyes of beneficiaries. And when that happens, even correct decisions feel arbitrary. Legitimacy is earned through process, through consistency, through explanation, and through visible independence. Trustees who explain how they decide rather than what they decide tend to maintain legitimacy even when outcomes are unpopular. Those who rely solely on formal authority often face challenge later, not because they're wrong, but because beneficiaries never understood the basis upon which the decisions were made. This distinction matters most in discretionary trusts. For discretion exercised without explanation feels like favoritism. Discretion exercised with process feels like judgment. And the law protects trustees who exercise judgment properly. Families tolerate just trustees who exercise it visibly. One of the most common trustee failures I see is a confusion of permission with obligation. A trustee feels authorized to act, so they act, without pausing to ask whether the action is appropriate. Trust law doesn't protect the impulsive use of power. It protects reasoned use of power. This is why trustees must understand not only what they can do, but why they're doing it. So let's look at powers and restraint, because there's an uncomfortable truth about trustee powers. Good trustees often use fewer powers, not more. They don't feel the need to demonstrate activity. They don't confuse motion with progress. They recognize that every exercise of power sets a precedent. Every distribution creates expectation. Every decision shapes future behavior. As a result, restraint is not weakness in trusteeship. It's competence. And yet families sometimes misinterpret this. A trustee who does not distribute is seen as obstructive. A trustee who asks questions is seen as difficult. In reality, these are often signs of a trustee who's actually taking their role seriously. Power exists to be used when necessary, not because it exists. Trustees who understand this tend to preserve trust capital, trust relationships, and their own position far more effectively over time. So, in terms of trustee duties, what must trustees do? If powers define what trustees can do, duties define what they must do. These duties are not optional. They can't be ignored, and they can't be fully contracted away. Let's look at them. So, core trustee duties. What do they include? They include the duty to act in accordance with the trustee, clearly. The duty to act in the best interests of the beneficiaries as a whole. Okay. The duty to act impartially between beneficiaries. That's logical. The duty to exercise powers personally and genuinely. The duty of care and skill. And of course, the duty to keep accounts and provide information. Now, each of these deserves attention. The duty to act in the best interests of the beneficiaries doesn't mean acting in the interests of the loudest beneficiary, the neediest beneficiary, or the most persuasive beneficiary. It means acting for the benefit of the trust as a whole over time. The duty of impartiality does not require equal outcomes. It requires fair consideration. This distinction is critical. Trustees are not obliged, after all, to treat beneficiaries equally. They're simply obliged to treat them properly. This is often misunderstood, particularly in discretionary trusts. Discretionary trustees are required to consider beneficiaries. They are not required to satisfy them. The duty of care and skill is judged objectively. Now, a professional trustee is often held to a higher standard than a lay trustee. But a lay trustee is not excused incompetence. Because if you accept the role, you accept the responsibility. Trusteeship's not a favor. It's a function with consequences. Now, one of the issues many trustees talk to me about is the management of tension. So I want to dwell on that for a moment. Trusteeship involves tension. It involves a tension between income and capital, between present need and future preservation, between compassion and discipline. The law doesn't expect trustees to eliminate this tension. It simply expects them to manage it properly. A trustee who avoids difficult decisions is not neutral. They're failing to exercise judgment. Equally, a trustee who imposes their own preferences without regard to beneficiaries is overreaching. The skill of trusteeship lies in navigating this middle ground, This is why experience matters. Judgment is not learned from documents. It's learned from exposure, from seeing how decisions play out over time, from recognizing patterns, from understanding human behavior. This is also why trustees need support. Good trustees seek advice. Bad trustees hide behind it. Advice informs judgment. It doesn't replace it. Now let me move on to discretion, because this is a word that is used very often when talking about trusteeship, and it's very often misunderstood. So let's clarify it. Discretion sits at the heart of trusteeship, but discretion does not mean freedom from scrutiny. Far from it. Trustees must consider relevant factors, also disregard irrelevant ones, and reach a decision they genuinely believe to be appropriate. They're not required to explain every decision to beneficiaries, but they must be able to explain it to themselves when they stand in front of the mirror every morning. And, if required, they're required to explain it to a court. This is where process matters, not bureaucracy. Process. Proper process protects trustees, documenting considerations, recording reasons, taking advice where appropriate. Now, none of this guarantees immunity, of course, but absence of process almost always guarantees vulnerability. A trustee who cannot explain how they reached a decision is exposed, regardless of outcome. Good decision-making is the trustee's first line of defense. So it's worth being even more explicit about one point. Trustees are not judged on outcomes. They're judged on process. Courts understand that trustees operate under uncertainty. They understand that markets move, families change, information is incomplete. So what courts look for is evidence that trustees identify decisions they're required to make, consider relevant factors, ignore irrelevant ones, take advice where appropriate, and finally reach a decision they genuinely believe to be in the interests of the trust. So a decision that turns out badly is not automatically a breach. A decision made without thought, documentation, or engagement very often is. This is why trustees who are outcome-focused rather than process-focused expose themselves unnecessarily. Trying to get it right is less important than being able to show how the decision was reached. Good trustees document their thinking not because they expect challenge, but because they understand that memory fades and narratives change. Process is not bureaucracy, it's protection. And when talking about protection, let's talk about something really uncomfortable, and that's personal liability. Because this is where things become really real. It's also the part that many people underestimate. Trustees can be personally liable, not in theory, in practice. It can arise where trustees act outside their powers, breach their duties, fail to supervise delegated functions, act dishonestly or recklessly, or prefer one beneficiary improperly. Importantly, acting with good intentions is not a defense. After all, famously, the road to hell is paved with good intentions, and trustees are judged by what they do, not what they meant. Professional trustees understand this instinctively. It's in the architecture. Lay trustees often do not. It's not a criticism, it's a reality. Indemnities and insurance are important, they help, but they don't eliminate risk and they don't protect against everything. Once appointed, a trustee cannot step back mentally. They can only step back formally. Remaining in name while disengaging in substance is one of the most dangerous positions a trustee can occupy. There is also an uncomfortable truth about personal liability, because many trustees remain in office longer than they should. They sense that circumstances have changed, that relationships have hardened, that expectations are misaligned, but they stay. Out of loyalty, perhaps, maybe out of inertia, maybe out of fear that resignation will be seen as failure. But in reality, timely resignation can be the most responsible act a trustee performs. A trustee who no longer has the confidence, independence, or indeed the energy to exercise judgment properly is already a risk. The law does not reward endurance. It rewards competence. And knowing when to step aside is part of trusteeship, not an abdication of it. So let's move on to the choosing of trustees, and the choosing of trustees wisely. Because given all this, the choice of trustee matters enormously. Families often default to familiarity, a sibling, a friend, a long-standing advisor, and that can definitely work, but can also fail badly. Familiarity does not equal suitability. Because trustees need independence, they need time, they need judgment, and they also need the ability to say no. They also need resilience. Trustees who seek approval struggle. Trustees who fear conflict retreat. Trustees who want to be liked often compromise discretion. None of it's personal, it's structural. Trusteeship is, after all, not a popularity contest. It's a role that requires calm authority and emotional distance. That's why it tends to favor those who are slightly older. A few grey hairs in a trustee never go wrong. But let me show you what independence looks like when it's genuinely tested. And this is another example from my book on trusteeship. Some years ago, I was asked to advise a South African family shortly after the death of their founder. He had built a diversified business spanning agriculture, logistics, and property. He was decisive, respected, and dominant. While he was alive, disagreements existed, but they never surfaced. His authority seemingly absorbed them. Now, once he was gone, that center and that absorption disappeared. 3 siblings inherited interests in all operating companies. Each was capable, each was committed, and each wanted something entirely different. One wanted liquidity and distance. Another wanted expansion and control. The third simply wanted stability and peace. None of these positions were unreasonable. Together, they were combustible. Advisors circled. Lawyers drafted options that favored their respective clans. Accountants ran numbers that proved that any outcome was viable. Meetings multiplied. Decisions stalled. What was missing was not intelligence or intent. It was independence. Every discussion drifted towards alignment. Who was more involved? Who had earned influence? Who had the stronger emotional claim to legacy? Without realizing it, the siblings were testing whether authority still existed and where it might settle. This was the moment that independence mattered. The solution was not to arbitrate between siblings, nor to impose a vision. It was to remove the contest altogether. We held a trust structure that held the operating assets governed by an independent trustee body with clearly defined powers. No sibling controlled it. No sibling could dominate it. Each remained a beneficiary, and none became an owner. The resistance, well, as you can imagine, was immediate. After all, independence is rarely welcomed at first. One sibling questioned why an outsider should decide. Another worried about the loss of influence, and a third feared conflict would become permanent and embedded. But independence doesn't mean indifference. The trustees listened carefully. Decisions were explained. Boundaries were held. When one sibling pushed hard for a distribution to fund an acquisition, the trustee declined. Not because the idea lacked merit, but because it compromised agreed risk parameters. When another sought a rapid exit, a structured pathway was created rather than a forced fire sale. Over time, something changed. The trust managed to achieve that arguments softened. The volume dropped. The siblings stopped negotiating through power and started working through process. They still disagreed, but the disagreement no longer threatened the whole. What this case illustrates is that independence is not about standing apart from people. It's about standing apart from pressure. It allows trustees to absorb tension without transmitting it, to decide without performing, to disappoint without fracturing. Trustees who can't stand independently will always be pulled towards the strongest voice in the room. Trustees who can will hold the room steady. That's the difference between trusteeship that merely survives and trusteeship that governs. So how can we ensure that trustees are supported properly? Because even the best trustees fail without support. Clear documentation matters, so does professional advice, so does governance. Trustees shouldn't be left to guess what is expected of them. They need clear trust documents, letters of wishes that guide, not dictate, access to competent advisors, and a governance framework that allows decisions to be made properly. Trustees should never be an afterthought. It should be designed deliberately. Families who invest time in trustee selection and support experience far fewer disputes, far fewer resignations, and far better long-term outcomes. And that long-term aspect of trusteeship is something that's rarely discussed. Trusts are often created to last decades. Trustees, however, rarely imagine themselves serving that long. Appointments are accepted with a vague sense of continuity, but without real reflection on what it means to remain responsible as circumstances evolve. Time changes everything. Families grow, beneficiaries age, values drift. What felt appropriate at the outset can feel inadequate or even dangerous 10 or 20 years later. A trustee's task is not to preserve the past, nor is it to chase the present. It's to steward continuity whilst allowing adaptation. This requires an unusual discipline. Trustees must respect original intent without becoming imprisoned by it. Letters of wishes help, but they're not scripture. They are context, not command. Trustees who treat them as immutable instructions often find themselves enforcing outdated assumptions on modern lives. I have seen trustees cling to historic distribution patterns long after they cease to make sense. Children who were supposedly supported generously at 25 are still being supported generously at 45. Structures designed to protect fragile heirs become mechanisms of dependency. The trustee, anxious not to deviate from precedent, becomes the enabler of stagnation. Good trustees revisit purpose regularly, not formally, not theatrically, but consciously. They ask whether the trust is still doing what it was meant to do, in light of who the beneficiaries have become. It's not a legal exercise, it's a judgment exercise, and it's one of the hardest parts of the role. Now, many times I like to think of trustees as shock absorbers, and I want to explain what I mean. Because it's a reality that trustees often function precisely as that, as shock absorbers. They absorb emotion, they absorb conflict, they absorb disappointment, they absorb pressure that would otherwise pass directly between family members. This role is rarely acknowledged, it's rarely thanked, and it's rarely understood by those outside it. Beneficiaries often experience trusteeship only at moments of friction. A request is refused, a decision is delayed, a condition is imposed, and in those moments, the trustee becomes the face of restraint. What beneficiaries don't see are the conversations behind the scenes, the trade-offs considered, the risks avoided, the tensions balanced. A trustee who performs this role well will sometimes appear obstructive. That is unavoidable. The mistake is to try to compensate for this by becoming accommodating. Trustees who seek emotional approval undermine their own authority. Over time, boundaries blur, expectations inflate, disappointment becomes personal rather than structural. The strongest trustees I know accept that they will sometimes be disliked. They don't court this, but they don't fear it either. They understand that trusteeship is not relational in the ordinary sense, it's fiduciary. The relationship is defined by duty, not reciprocity. This emotional distance is not coldness, it's professionalism. Now let's talk a little bit about communication, because communication is often misunderstood in trusteeship. Beneficiaries ask frequently for transparency. Trustees respond by providing information. That's appropriate. But transparency does not require negotiation. A trustee can explain a decision without inviting debate. They can outline reasoning without opening a door to bargaining. They can listen without yielding authority. This distinction is subtle but vital. Trustees who slip into negotiation risk transforming discretion into entitlement. Every explanation becomes a precedent. Every concession becomes an expectation. Good trustees communicate clearly and calmly. They explain the framework. They articulate constraints. They make it clear what can be discussed, but also what cannot. They don't justify themselves endlessly. They don't argue. They don't personalize disagreement. This style of communication takes practice over years. It also takes confidence in one's own judgment. Where trustees struggle most is with articulate, well-advised beneficiaries who present their case persuasively. The temptation is to engage on merits alone. But trustees must remember that persuasion is not the test. Appropriateness is. Now let's look at delegation. Because modern trusteeship relies heavily on delegation. Investment managers, property managers, corporate service providers, advisors of every description. Delegation is necessary, but it's also dangerous when it's misunderstood. Trustees may delegate functions. They cannot delegate responsibility. This sounds obvious. In practice, it's often forgotten. Trustees who rely unquestioningly on advisors expose themselves, not because advisors are incompetent, but because advisors don't carry fiduciary responsibility for outcomes. A trustee who signs what an advisor prepares without independent assessment is not protected by the advisor's reputation. They're exposed by their own passivity. Good trustees use advisors as inputs, not as shields. They ask questions, they challenge assumptions, they document why advice was accepted or rejected. This is particularly important in investment matters. Trustees are not required to be investment expert, but they are required to exercise oversight, understanding risk parameters, monitoring performance, ensuring alignment with trust objectives. These are trustee responsibilities, not investment manager responsibilities. Delegation is not abdication. Now let's talk about something difficult, which is failure. Most trusteeship failures don't arise from fraud or malice. They arise from avoidance, an avoidance of conflict, an avoidance of difficult conversations, an avoidance of decisive action. Trustees see problems emerging and hope that they'll just resolve themselves. Beneficiaries' behavior becomes concerning. Governance weakens. Documentation falls behind. By the time action is taken, positions have hardened, trust has eroded, options have narrowed. Early intervention is uncomfortable. Late intervention is expensive. This is where experience matters. Experienced trustees recognize early warning signs, patterns of behavior, shifts in tone, and requests that test boundaries. The sooner they act, the better, because they need to act proportionately and with minimal drama. In contrast, trustees who delay often find themselves forced into extreme measures, suspensions, court applications, forced exits. At that point, trusteeship becomes adversarial, and from that, no one wins. There's one final aspect of trusteeship, and indeed of life, that deserves acknowledgement. Trustees work in the shadow of mortality. Trust exists precisely because people age, decline, and die. Families fracture because time passes. Wealth creates complexity precisely because lives end. Trustees are often present at moments of loss, secular deaths, beneficiary illnesses, generational transitions. This proximity to mortality gives trusteeship a gravity that few professional roles carry. Good trustees respect this. They act with restraints at moments of grief. They slow decisions when emotions are high. They recognize when firmness must be paired with compassion. This doesn't mean abandoning discipline. It means exercising judgment, but with humanity. The law doesn't prohibit empathy. It just requires control. So, what have we learned from this podcast episode? Firstly, that trusteeship is not administrative. A trustee is the legal owner of the trust property, carrying real authority and real exposure. Secondly, the power and duty are inseparable. Wide powers in a modern trustee do not create freedom, they create responsibility. Third, that integrity is tested in moments where silence would be easier. Trusteeship fails less through scandal than through gradual erosion. Fourth, that legitimacy is behavioral. Authority may come from the deed, but credibility comes from process, consistency, and visible independence. Fifth, that duties are not abstract. Acting in beneficiaries' interest does not mean pleasing them. Impartiality does not mean equality. Sixth, that discretion is defensible only when process is clear. Trustees are judged less on outcome than on how they reached a decision. Seventh, that personal liability is real. Good intentions do not excuse poor execution. Eighth, that independence is not indifference. Trustees must be able to absorb pressure without transmitting it, and to disappoint without destabilizing the structure. Ninth, that trusteeship is sustained over time. Trusts evolve, families change, purpose must be revisited consciously. 10th, that trustees act as shock absorbers. They manage tension rather than eliminate it. And finally, that trusteeship is not a title. It's an ongoing acceptance of authority with accountability attached. And that was Trusteeship Unpacked. Join me next time to delve deeper into trusteeship and unpack professional versus private or lay trustees, their trade-offs and their risks. Until next time, this is Alexander von der Fellen.